Hello, everybody. Hello, everyone. Welcome to day 3 of real estate school. We're very excited to have you with us. We're going through another boring day of real estate notes. And if you are watching with us on Zoom, we have our Spanish translation up. So thank you very much to my friend Andres de Arense for translating live into Spanish. So if you're just logging in now and you want to have the Spanish option on your Zoom, go down to where it says interpretation, click on that button and select Spanish, and then you will hear Andres speaking instead of me speaking. You also have the option of ordering these books in Spanish. We want to make sure that you are comfortable while we're going through this. I have a quick question here before we get started. John Davis says, hi, I missed yesterday, and I wanted to know if there was some paperwork links sent out yesterday or something like that. The classes are all recorded. They are all up on YouTube. They are on Facebook. And so if you ever miss a session, feel free to go back into our Facebook or go into our YouTube and watch all of the classes, and you could have all of your notes updated. But no, we did not send out any valuable links. That's going to be on day 5 of this program. We're actually going to walk you through the CalPACES link, getting registered, getting your books, so that you can actually start participating in the Finder program in Commission Boot Camp on January 25th on Monday with Andres, Amy, and Zach. So that's going to be on day 6 of the program. So again, we got the Spanish translation going. We're going to jump into day 3 today. We've got a good healthy amount of reading, 44 pages. We have Chapter 7, Civil Rights and Fair Housing Laws. Chapter 8, and actually this is pretty good stuff today. This is not what I would normally call the boring stuff. And in fact, I have a good book recommendation for you. If you are interested in anything deeper about what we've got going on, we're going to dive into this more later in the semester, but I would definitely recommend checking out The Color of Law by Richard Rothstein. Richard Rothstein is a fellow administrator on lab coat agents, and he is a wealth of knowledge and a lawyer with the NAACP. So feel free to check that out or look up these topics like redlining that you're going to hear coming up on YouTube. And there's a lot of really great information out there. One is by The Roots, which we'll talk about later, and then there's another one by True TV. Okay, we're going to go ahead and jump in right now to all of the boring stuff. Without further ado, Fair Employment and Housing Acts, Chapter 9, Housing Financial Discrimination. Chapter 10, Equal Credit Opportunity Act. Chapter 11, Home Mortgage Disclosure Act. Chapter 12, HUD Advertising and Guidelines. So this is all going to be much less dry than yesterday. So without further ado, let's go ahead and jump in and see how much of this reading that we can get knocked out. You ready to start translating, Andres? Here we go. Time to change it to this good stuff. Boom, boom, boom. Okay. All right, civil rights and fair housing laws. Oh, so again, we skipped the blue parts here. Property rights cannot be based on status. Regardless of race, all citizens of the United States have the right to purchase or rent real estate under the Federal Civil Rights Act. Further, all individuals within the United States are given the same rights to make and enforce contracts, rental and lease agreements, sue, be sued, enjoy the full benefits of the law, and be subject to the same punishments, penalties, taxes, and licenses, regardless of race or legal status. The Federal Civil Rights Act applies to race discrimination on the sale of rental of all types of real estate, both residential and commercial. Racially motivated activities in any real estate releasing transaction are prohibited. Federal protection against racial discrimination, given under the Civil Rights Act is broad protection which applies to types of discrimination prohibited in all activities between individuals present in the country. Anti-discrimination in residential property. While the Federal Civil Rights Act provides general protection under all prohibited discriminatory activity, the Federal Fair Housing Act, the FFHA, protections are specifically limited to dwellings, included rental housing. A dwelling includes any building or structure that is occupied or designed to be occupied as a residence by one or more families. A dwelling also includes vacant land and offered for lease for residential dwelling purposes, such as a lot or space made available to hold a mobile home unit. The FFHA bars the use of any discriminatory actions as a seller, a landlord, or property manager might take against property buyer or tenant based on an individual's race or color, national origin, religion, sex, familial status, or handicap. Now, this is all important stuff. I would encourage you to pay attention. Some real estate agents should have paid better attention during this portion of their education. Familial status refers to whether a household includes individuals under the age of 18 in the legal custody of a parent or legally designated guardian. Handicapped persons are individuals who have a physical or mental impairment which substantially limits the individual's life activities or a record of or are regarded as having physical or mental impairment. Now, specifically in this area, Murrieta, Temecula, Winchester, Fallbrook, there's a lot of military. And post-traumatic stress disorder does extend to into this category. So there are people that have service animals, which we'll get into more later. So you're going to want to sort of keep an eye on things like this as you proceed in your career. Oh, we lost the. Bring that right back, and then we're going to jump right back in. Okay, the term handicap excludes individuals who illegally use a controlled substance. However, alcoholics, addicts are protected as handicapped individuals. Qualifying and possessing tenants. The FFHA prohibits a seller, landlord, or property manager from unlawfully discriminating against individuals during solicitations and negotiations for the sale or rental of a dwelling. Thus, in the context of leasing, a landlord or property manager may not refuse to rent a dwelling or to negotiate the rental of a dwelling for prohibited discriminatory reasons, impose different rental charges on a dwelling for prohibited discriminatory reasons, use discriminatory qualification criteria or different procedures for processing applications in a rental of a dwelling, or evict tenants of guests for prohibited discriminatory reasons. Different terms, different privileges. Consider a broker who is hired by a residential apartment landlord to perform property management activities. One of the broker's duties as a property manager is to locate tenants to fill vacancies. A tenant from a religious minority group contacts the broker about the availability of an apartment. The broker or their agent informs the prospective tenant of the monthly rent. However, the rate the broker communicates to the prospective tenant is higher than the rent non-minority tenants are asked to pay for similar apartments. When the prospective minority tenant asks the broker for an application, the broker informs the tenant a non-refundable screening fee is charged to process the application. The creditworthy minority tenant fills out the application, pays the fee, and is told the processing will take several days. In the meantime, a non-minority tenant inquires about the rental of the same or similar apartment. The monthly rent rate, the broker quotes the non-minority, is lower than the rent rate the minority tenant was quoted, even though the non-minority tenant is not as creditworthy as the minority tenant. Further, the non-minority tenant is not charged a screening fee with their application. The apartment is immediately rented to the non-minority tenant. Here, the broker's actions were racially or religiously motivated, a violation of the FFHA. The broker misrepresented the availability of the apartment based on the tenant's religion by using different procedures and qualification standards and accepting and processing the tenant's application. Selective reduction. Selective reduction of buyers or tenant privileges, conditions, services, and facilities offered to protected individuals is prohibited. Selective reduction can take the form of using less favorable provisions in lease or purchase agreements, such as in rental charges and closing requirements, delaying or failing to inform maintenance, limiting use of privileges, services of facilities to different classes of individuals, or refusing to failing to provide services or facilities due to an individual's refusal to provide sexual favors. Further, the landlord or property manager may not discriminate based on an individual's status by representing that dwelling is not available for rent in order to direct the individual to a particular Section 8 project or neighborhood when the dwelling is available. This project is called steering. Steering involves the restriction of an individual seeking to rent or purchase a dwelling in a community, neighborhood, or development when the guidance perpetuates segregated housing patterns. Now, Section 8 housing, for those of you that don't know, is a voucher program that people have to apply for, and then it gives families and individuals a credit voucher for rent so that they can apply to rent that helps them to move into areas where perhaps maybe the schools are better and whatnot. When I was younger, my family participated in Section 8, and I can tell you that there were not a lot of areas, not a lot of neighborhoods, not a lot of landlords that accepted Section 8 vouchers, and so steering very much exists, and you hear people speak about it very loudly, unfortunately. Okay, discrimination in advertisement. A broker or their agent making a notice, statement, or advertisement when handling the sale or rental of a dwelling unit is barred from using any wording that indicates a discriminatory preference or limitation against individuals of a protected classes of people. The prohibition against prohibited discriminatory advertisements applies to all oral and written statements. Notices and statements include any applications, flyers, brochures, deeds, signs, banners, posters, and billboards used to advertise the availability of a dwelling for rent. Blockbusting for exploitation. This is something that you can learn more about on YouTube, and it's also, you'll find it in the book which we talked about earlier, The Color of Law by Richard Rothstein. Blockbusting for exploitation. As an agent, residential landlord, or property manager may not induce or attempt to induce an individual to offer or abstain from offering a dwelling to prevent the entry of certain classes of people into the neighborhood. This prohibited practice is known as blockbusting. Further, a landlord or agent's actual financial gain is not necessary to establish a blockbusting conduct. The mere profit motivation is sufficient to establish blockbusting activity. Examples of blockbusting activities by a landlord or property manager include encouraging an owner-occupant to offer their home for sale or rent by insinuating that a neighborhood is undergoing or is about to undergo a change in the race, color, religion, sex, handicap, familial status, or national origin of its residents. You hear things like this in the "there goes the neighborhood" type of attitude that you see sometimes in suburbia, in which you see white flight, which again is outlined further online, which we could go into later, but that's just two examples. Discouraging an owner-occupant from offering their home for sale or rent by claiming the entry of individuals of a particular race, color, religion, sex, familial status, handicap, or national origin will result in undesirable consequences for neighborhood or community, such as an increase in criminal activity or decline in schools and other facilities. People will really admit some pretty heinous things to you in listing appointments, unfortunately, in this industry. They'll talk about, different minority groups moving into neighborhoods. They'll talk about, and Andres, I'm sure you see the same thing. But what we need to do is understand that our job requires that we stand up to this sort of things and that we do not practice these sort of discriminatory acts. Exemptions from prohibited discrimination. These are exemptions to the FFHA prohibitions. A landlord who rents out a single-family residence is exempt from FFHA discrimination prohibitions if they own 3 or fewer single-family residences, do not use a real estate licensee to negotiate or handle the tenancy, and do not use a publication, posting, or mailing for any discriminatory advertisement. So like for the same reason that a FSBO is not open to the same standard that an individual agent is, just is the same here. Thus the FFHA apply to all notices, statements, and advertisements promoting rentals by anyone in the business of renting dwellings. A person is in the business of renting or selling dwellings if the person has participated within the last 12 months as a principal in 3 or more transactions involving the sale or rental of any dwelling or interest in a dwelling, has participated within the last 12 months as an agent negotiating two or more transactions involving in the sale or rental of any dwelling or interest in a dwelling, excluding the agent's personal residence, or is the owner of a dwelling structured intended to be occupied by 5 or more families. Let's see here. For you guys here on the Zoom end, I forgot to pin my video, so I'll do that now so you guys aren't straining your eyeballs. My apologies. And then feel free, guys, if you have any questions, to enter them into the chat box online, on Facebook, or in Zoom, or in your comments on YouTube, and we'll be happy to get you guys answers to your questions. If a broker is the agent for any of the participants in the sale or rental transaction of the FFHA, anti-discrimination rules apply. However, attorneys, escrow agents, title companies, and professionals other than brokers who are employed by a landlord to complete a transaction do not bring the transaction under the FFHA unless they participate in the negotiations with the buyer or tenant. Limited exemptions. Also, exempt from the FFHA discrimination rules is the sale or rental of a residence in a 1 to 4 unit residential rental property, which is occupied in part by the owner. Religious organizations who limit the sale, rental, or occupancy of the dwelling to individuals of the same religion are also exempt, provided dwellings is owned for non-commercial reasons. No religious exemptions exist if the religion is restricted to individuals of a particular race, color, or national origin. Private clubs, which provide their members with residential dwelling space for non-commercial purposes, may limit rental or occupancy of dwellings to its members. Gross. Housing for older persons. Finally, housing qualified for older citizens which exclude children is not considered prohibited discrimination against buyers or tenants with children based on familial status. However, for housing to exclude children, it needs to first qualify as housing for the elderly. A provision in a written instrument which refers to qualified senior citizen housing is enforceable as allowable age discrimination. A senior citizen housing project is housing intended for solely occupied by persons 62 years of age or older, or intended and operated for occupancy by persons 55 years of age or older. Failure to comply with the FFHA. Any individuals who claims they have been injured by a prohibited discrimination housing practice under the FFHA or believes they will be injured by a practice. Gosh darn it. Sorry about that, guys. It's a little bit frustrating. Any individual injured by such practice is considered an aggrieved individual. An aggrieved individual may file a complaint with the Secretary of Housing and Urban Development, HUD, within 1 year of the alleged discriminatory housing practice. HUD then attempts to resolve the dispute by having the parties enter into informal negotiations called mediation. If mediation is not successful, a judicial action may be initiated by HUD as a complaint to resolve the issue of discrimination. The dispute will then be resolved by an administrative law judge. Any party to the complaint may elect to have the claims decided in a civil action before a court of law in lieu of using the administrative law judge. When a real estate broker subjected to judicial action is found guilty of discriminatory housing practices, HUD is to notify the DRE, and we recommend disciplinary action. When a court determines the discriminatory housing practices have taken place, actual and punitive amounts of money awards may be granted. Also, an order may be issued preventing the landlord or brokers from engaging in future discriminatory housing practice. California's UNRRA Civil Rights Act. California's UNRRA Civil Rights Act, another anti-discrimination law, prohibits discrimination by a business establishment based on numerous status classifications, including an individual's sex, race, color, religion, ancestry, national origin, disability, or medical condition. However, age restriction is a legitimate discrimination as long as the restriction is a project that qualifies as senior citizen housing development. The UNRRA Civil Rights Act applies to anyone in the business of providing housing. Brokers, developers, apartment owners, condominium owners, and single-family residential owners renting or selling are considered to be in the business of providing housing. As a business establishment, landlords may not boycott, blacklist, refuse to lease or rent because of the race, creed, religion, color, national origin, sex, disability, or medical condition of an individual or that individual's business partners, members, stockholders, directors, officers, managers, agents, employees, business associates, or customers. Full and equal access guaranteed. Consider a blind prospective tenant who has a guide dog and seeks to rent an available unit in a multi-unit residential dwelling structure. The landlord refuses to rent to a unit to the blind tenant, claiming the guide dog violates the building's pet restriction in the covenants, conditions, and restrictions, or CC&Rs. The blind tenant claims the landlord is discriminating against them due to their disability since the landlord denied them housing on account of the guide dog. Here, a landlord may or may not refuse to rent residential property to a blind tenant because of the inclusion of the tenant's guide dog. A landlord may not refuse to rent. Landlords are also prohibited from discriminating against tenants with dogs specially trained to assist deaf and other disabled individuals. Fair housing for disabled individuals. Disabled individuals are protected from discrimination when renting or leasing California residential real estate. A disabled individual, if anyone, is who has a physical or mental impairment which significantly limits major life activities, has a record of a disability, or is regarded as being disabled. People with disabilities are entitled to full and equal access to housing accommodations offered for rent. The only exception is the rental of no more than one room in a single-family residence. The example of a blind tenant and their seeing eye dog illustrate how a landlord might attempt to avoid anti-discrimination laws, while the landlord claims to justify their behavior based on their equal application of a single pet restriction rule to pet owners, an unprotected class of people. The refusal to rent to a disabled tenant based on their reliance of a trained dog is a prohibited discrimination. Accommodating the disabled. A landlord is not required to structurally modify existing residential rental property to meet the special needs of disabled tenants. Although not required to modify the structure for a disabled tenant, the landlord is to allow the tenant to make reasonable modifications themselves or pay the landlord to do so. The landlord may require this disabled tenant who modifies the structure to restore the property to its original condition when the tenancy is terminated. Anti-discrimination laws require new residential properties consisting of 4 or more units per building to be built to allow access to disabled individuals. Required improvements include kitchens and bathrooms designed to allow access to disabled tenants in addition to wheelchair ramps. Failure to provide the disabled with access to newly constructed residential property with 4 or more units is prohibited discrimination. California prohibitions against discrimination in housing. California prohibits discrimination in the sale or rental of housing accommodations based on an individual's race, color, religion, sex, sexual orientation, gender identity, genetic information, marital status, national origin, ancestry, familial status, source of income or disability. This list is protected individuals is more extensive than all others. Discriminatory activities and conduct include making a written or oral inquiry into the race, sex, disability, etc. of any individual seeking to rent housing. Ads or notices for rental housing which state or infer preferences or limitations based on any of the prohibited discrimination factors. A broker refusing to represent an individual in a real estate transaction based on any prohibited factor, and any other practice that denies housing to a member of the protected class, The denial of housing based on the landlord or a broker's perception that a prospective buyer or tenant has any of the protected characteristics is absolutely prohibited. An individual who has been the victim of discriminatory housing practices may recover their money losses. But the truth is good luck. That's one of those things that's very difficult to prove, unfortunately, but that doesn't mean that the fight isn't worth fighting. Income standards for tenants. Standards of conduct applied equally by a broker to all individuals are not classified as prohibited discrimination against a protected group of individuals as they are considered reasonable and thus permitted. For example, to qualify a tenant for occupancy, Based on their creditworthiness, which is not a prohibited discrimination, a landlord or property manager may establish income ratios or standards to determine a tenant's ability to pay the rent. The higher the ratio of income rent established by a landlord, the less of a risk of loss of rent borne by a landlord. The lower the ratio established by the landlord, the greater the risk of their loss of rent. Once set, the ratio is applied to all prospective tenants equally. However, two or more individuals who desire to live in the same unit might apply to rent a unit. Whether related or unrelated, married or not, the income of all tenants is to be treated the total income used by the landlord to determine their collective eligibility to qualify to pay rent and the amount sought for the unit. Separately, each prospective tenant may be unable to qualify by meeting the income standard for the total rent sought by the landlord. However, if aggregating the income of all who intend to occupy the unit and enter the rental or lease agreements results in total income sufficient under the ratio applied to qualify a tenant or tenants for occupancy, the tenants qualify. Also, under the rent subsidy program, such as Section 8, which we discussed earlier, housing arrangements, the landlord or property manager will evaluate the tenant's income when determining whether the tenant qualifies to pay based on only the portion of the rent that is not subsidized. Now, to bring this from rental applications into residential real estate, you've seen EXP recently, our state broker, Debbie Penny, has told us no longer use love letters. It is not a practice that is allowed by EXP. It is prohibitado. And so the reason for this is the traditional practice real estate agents do, especially in a multiple offer situation, which is what we're seeing a lot of right now with this being such a heavy seller's market. Buyers are competing, so they're writing love letters. They write a letter, they include pictures of themselves, pictures of their family. Well, what happens is when people see the pictures and they see the family, it's supposed to endear them, but then we might see the opposite. So I actually think that we need to take it one step further and remove the names from the contracts, because I feel like that would be the next logical step in making sure that the best offer is accepted and not the offer which appeals most to the palate of the client. Okay, moving forward. Familial status. Recall that familial status in anti-discrimination laws refers to whether children under the age of 18 will be living with a parent or guardian on the premises. Rental policies excluding children under the age of 18 are classified as prohibited discrimination under state as well as federal laws unless the property qualifies as senior citizen housing. Consider marital status of co-applicants for housing. At least I think that says housing. You see that? Marital status of co-applicants for housing. Consider a landlord who refuses to rent an apartment to an unmarried couple based on the landlord's religious beliefs about such conduct. The couple files a complaint with the California Fair Employment and Housing Commission, claiming the landlord violated fair housing laws that prohibit discrimination based on marital status. The landlord claims they are exempt since renting to an unmarried couple violates the landlord's religious beliefs regarding the cohabitation of unmarried couples. However, the landlord's refusal to rent to unmarried couples violates the fair housing laws. The landlord's religious beliefs do not also require them to participate in the business of renting dwelling units. Thus, fair housing laws prohibiting discrimination based on marital status beliefs do not interfere with the practice of the landlord's religion. The faithful landlord can go into the business that does not violate their religious convictions. Guidelines for broker conduct. The DRE has regulations prohibiting discriminatory practices by real estate brokers acting on behalf of a client. A broker or their agent engaging in their discriminatory business practices may be disciplined by the DRE. Prohibited practices include any situation in which a broker, while acting as an agent, discriminates against anyone based on race, color, sex, religion, ancestry, disability, marital status, or national origin. Example of discriminatory practices include refusal to negotiate for the sale or rental of real estate, refusing to show property to or provide information or steering clients away from specific properties. There are actually examples of agents being caught doing this, again, on YouTube. You could watch a collage yourself. Refusing to accept a listing, publishing or distributing advertisements that indicate a discriminatory preference, any discrimination in the course of providing property management services, agreeing with the client to discriminate when selling or leasing the client's property, such as agreeing not to show the property to members of a particular minority group, attempting to discourage the sale or rental of real estate based on representations of the race, sex, disability, etc. of other inhabitants in area, and encouraging or permitting employees to engage in discriminatory practices. Hey, kudos for hanging in there, everybody. I appreciate that. Believe it or not, I do this twice a day. All right, here we go. Disclosure of disability of other inhabitants. Consider a broker who is aware a licensed care facility for disabled people is located in a single-family residence near a residence the prospective tenant is interested in renting. The presence of the facility might influence the tenant's decision to rent the property. However, for the broker or their agents to inform the tenant of their facility would be unlawful discrimination. The broker may not attempt to influence the tenant's decision based on representations of the disability of the other inhabitants in the area. Cases in point: prohibited discrimination. So this is an example of an actual case in 1971. An ethnic or religious minority tenant seeks to rent an apartment. The landlord informs the prospective tenant they cannot rent the apartment until they complete a credit check. The landlord also declines to accept a deposit from the tenant. Later that same day, a non-minority tenant seeks to rent the same apartment. The landlord agrees to rent the apartment to the non-minority tenant without first requiring a credit check, and immediately accepts the tenant's check for a deposit on the apartment. The minority tenant is informed the apartment has been rented to another individual. The minority tenant files a complaint against the landlord, claiming the landlord discriminated against them based on their ethnicity or religion by refusing to rent them an apartment. The landlord claims no discrimination occurred since they were entitled to require a credit check of prospective tenants. However, requiring a credit check of minority tenants, but not non-minority tenants, is a prohibited discriminatory practice, which allows the minority tenant to recover their money losses. This is Stearns versus Fair Employment Practice Commission. However, on a direct inquiry from a tenant, the broker or agent needs to respond based on their knowledge of the existence of a care facility. No duty exists to disclose the prior tenant's affliction with the HIV virus or AIDS. Further, California public policy prohibits a broker from responding to a buyer or tenant's inquiry for disclosure of a prior occupant's affliction with AIDS. Individuals afflicted with the HIV virus are considered handicapped and are protected by the FFHA. Broker's duty to manage employees. A broker has a duty to advise their agents and employees of anti-discrimination rules, including DRE regulations, the Unruh Civil Rights Act, the California Fair Employment and Housing Act, and the FFHA. The broker, in addition to being responsible for their own conduct, owes the public a duty to ensure their employees follow anti-discrimination regulations when acting as agents on their broker's behalf. Disclosing a death. An owner, landlord, or property manager will voluntarily disclose to prospective buyers and tenants the death of a prior occupant on the premises which occurred more than 3 years earlier when they have reason to believe the death might affect the buyer's decision to purchase or the tenant's decision to lease. Further, the seller, seller's agent, landlord, and property manager will disclose their knowledge of any deaths which took place on the property in response to a direct inquiry. Consider a tenant who asks the property manager if any AIDS-related deaths occurred on the property. If the property manager is aware an AIDS-related death occurred on the property, they have a duty on direct inquiry from the tenant to disclose the prior occupant's death and the death was AIDS-related. If the property manager has no knowledge of any AIDS-related deaths occurring on the property, they will disclose their lack of knowledge and whether or not they intend to undertake an investigation to determine if an AIDS-related death occurred on the property. Death as a material fact. Consider a property manager who is aware of a death from any cause occurred on the property within 3 years of the commencement of a tenant's lease agreement. The tenant has not inquired if any deaths have occurred on the property. Here, the property manager will need to determine if the death on the property is a material fact which might affect the tenant's decision to lease and occupy the property. The property manager or the seller's agent, as good practice, discloses any death occurring on the property within 3 years when they have reason to believe the fact might affect the tenant's decision to lease. However, on inquiry from the tenant, the property manager discloses their knowledge of any death, including age-related deaths, which occurred on the property within the last 3 years. Now, there are some clients, I can't remember if I told you guys this or about the high school class, that don't even want to go into a house where somebody has died, and it is like a legit deal breaker for them. And there are other people who don't really care because that's part of life. Chapter 8, fair housing. And so let's check in really quick on, let's see, we're on page 65. We are going to be reading all the way to 85. So we've got 20 more pages to read today, and we've got 22 more minutes of class. Let's make it happen. All right, discriminatory practices, exemptions, and remedies. Consider a minority tenant who seeks to rent an apartment. The landlord states they will not rent an apartment to a tenant until a credit check has been completed. The landlord declines to accept the deposit. I feel like we already went over this part. Later that same day, we did. We're repeating things, aren't we? Okay, so in that situation that we discussed earlier, was the landlord's conduct discriminatory? Yes. Requiring a credit check of minority tenants but not non-minority tenants is an unlawful discriminatory practice. The minority tenant is entitled to an award for money collectible from the landlord. Prohibited factors. California law prohibits discrimination in the sale or rental of housing accommodations. Discriminatory practices include making an inquiry, written or oral, into the race, sex, disability, or of any individual seeking to rent the purchase or housing, publishing ads or notices for the sale or rental of housing which indicate a preference or limitation based on the prohibited factors, use of prohibited discrimination when providing or arranging real estate mortgages and financing, refusal based on prohibited factors by a broker to represent an individual in a real estate transaction, and any other practice that denies housing to a member of a protected class. The Department of Fair Employment and Housing is California government's agency which enforces the anti-discrimination law. Any individual who feels they have been discriminated against may file a complaint with the department. The department investigates the complaint to determine any wrongful conduct. If ground exists, the department then seeks to resolve the situation through discussions with the individuals against whom the complaint was made. If the department believes a discriminatory practice has occurred, it will first attempt to reach a resolution through the department's mandatory dispute resolution division. The dispute resolution is provided without charge to either party. If the dispute cannot be effectively resolved, the department will file a civil action on behalf of the individual who was discriminated against in the county where the discriminatory conduct is alleged to have occurred. Unlawful discrimination based on familial status. Familial status in anti-discrimination law refers to a situation in which children are under the age of 18 living with a parent and guardian. I feel like, again, we went over a lot of this stuff. Until familial status was added to the anti-discrimination laws in 1992, it was legal to exclude minors under the age of 18 from housing accommodations. However, policies excluding children under the age of 18 are now classified as unlawful discrimination unless the property qualifies as senior citizen housing. Religious exemption. An exemption for anti-discrimination laws exists for religious organizations. Religious organizations may give preference to members of the same religious group when providing residential property for non-commercial purposes. However, membership in that religion may not be restricted on account of race, color, or national origin. Further, a landlord may not use religious beliefs such as those regarding marital status to shield their discriminatory conduct. DRE regulation of discrimination. The Department of Real Estate, the DRE, also enforces numerous regulations prohibiting discriminatory practices by real estate brokers and agents. A broker or agent found guilty of engaging in discriminatory business practices may be disciplined by the DRE. DRE prohibit. That's not that DRE. It's the DRE, the Department of Real Estate. The DRE prohibited discriminatory practices include situations in which a broker or agent discriminates against anyone based on race, color, sex, religion, ancestry, disability, marital status, or national origin. Blatant discriminatory practices are not as common now as they once were. However, the DRE's focus now has shifted to more subtle forms of discrimination. Implicit discrimination. Implicit discriminatory practices are those which are not openly discriminatory, but result in discriminatory effects. A broker has a duty to advise their agents and employees of anti-discrimination rules. This includes DRE regulations, the Unruh Civil Rights Act, the Fair Employment and Housing Act, and the Federal Fair Housing Law. Thus, the broker is not only responsible for their own conduct, but need to also ensure their employees follow anti-discrimination regulations when acting as agents on their behalf. Chapter 8, Summary. We already read it. We don't need to read it again. Chapter 9, the Housing Financial Discrimination Act of 1977. California's fair lending laws. I'm hungry. To achieve a healthy state economy, all residential housings for sale need to be available to any home buyer who is creditworthy and qualifies for purchase assist financing. An efficient real estate market requires the value of housing to be immune from fluctuations caused by lenders who arbitrarily deny financing to qualified homeowners. Thus, state law prohibits discriminatory lending practices. The goal of anti-discrimination law in home financing is to increase the availability of housing to creditworthy buyers, and increase lending in communities where lenders have made conventional home mortgages unavailable. Increased availability of home mortgages. Lenders need to make financing available to qualified creditworthy mortgage applicants to buy, build, repair, improve, or refinance an existing mortgage on 1 to 4 unit owner-occupied residences, or improve 1 to 4 unit residences which are not owner-occupied. Lenders violate public policy when they indicate a discriminatory preference by denying or approving financing to creditworthy mortgage applicants based on the applicant's protected status. In a community which is composed mainly of residents of a certain race, color, religion, or other protected class, a lender may not refuse to fund a mortgage based on the demographics of that community, or appraise real estate in that community at a lower value than comparable real estate in communities predominantly composed of non-minority residents. Failure to provide financing in certain communities is called redlining. There were banks being caught using redlining maps as recently as 2012. So this is definitely something that the repercussions are still very much alive today. So redlining is specifically targeted for correction by the law since it adversely affects the health, welfare, and safety of California residents. Lenders who deny mortgage applications based on the characteristics of the community discourages homeownership in that community. Thus, redlining leads to a decline in the quality and quantity of housing in areas where financing is generally available. And again, we're going to get into this later in the course. We're going to watch videos that explain exactly what redlining is and what the effects are. But we'll get into this more later. However, a lender can consider neighborhood conditions when making a mortgage under certain circumstances. When doing so, the lender is required to demonstrate a mortgage denial is based on neighborhood conditions, which render the mortgage unsafe and unsound as a matter of good business practice. Further, if the property's topography, structure, or location is unsafe or unhealthy, the lender is not required to provide purchase assist financing. Shout out to Andres really quick. Good man. I appreciate you translating all of this to Spanish. I can't even handle this in English. I'm reading it. You're doing it in real time. I appreciate you, sir. All right. Making it possible for everybody. Okay. Did we already read this crap? Let's say that we read it. However, a lender... Oh, no, wait. We did not. And this isn't crap. I'm sorry. My brain is all over the place. Failure to provide financing in certain communities is called redlining. Redlining is specifically targeted for correction by the law since it adversely affects health, welfare, and safety of California residents. Lenders who deny mortgage applications based on the characteristics of the community discourages homeownership in that community. Thus, redlining leads to decline in the quality and quantity of housing in areas where financing is generally unavailable. However, a lender can consider neighborhood conditions when making a mortgage under certain circumstances. When doing so, the lender is required to demonstrate a mortgage denial is based on neighborhood conditions which render the mortgage unsafe and unsound as a matter of good business practice. Further, if the property's topography, structure, or location is unsafe or unhealthy, the lender is not required to provide purchase assist financing. Notice of loan applicants' rights. Lenders are required to post in a conspicuous public location at their place of business a written notice informing applicants for mortgages to be secured by owner-occupied 1 to 4 unit residential property of their right to file lending discrimination claims and the name and address of the Secretary of California Business, Consumer Services, and Housing Agency. Lenders subject to this posting requirement include state-regulated banks, thrifts, public agencies, or other institutions which make, arrange, or buy mortgages funded to buy, build, repair, improve, or refinance 1 to 4 unit owner-occupied housing. Administrative remedies. A mortgage applicant may file a discrimination claim with the agency against a state-regulated lender if the applicant believes their mortgage application was denied due to their race, color, religion, sex, marital status, national origin, ancestry, or any other protected classifications described above, or trends, conditions, or characteristics of the community where the real estate is located. A home mortgage applicant who believes they have been unfairly discriminated against by a state lending institution needs to exhaust the agency administrative remedies before suing the lender for money losses. Federally regulated banks and thrifts are not subject to state regulation and discipline. Once the claim is received, the agency will attempt to work with the lender to end any unlawful discriminatory lending practices. The agency will determine if the lender has engaged in an unlawful discriminatory practice within 30 days of receiving the complaint. The agency will then serve the lender with its written decision and an order requiring the lender to end the unlawful discriminatory practice. The order will also require the lender to review the mortgage application under non-discriminatory terms and provide the denied financing if feasible. The lender may also be required to pay the borrower's money losses in an amount no greater than $1,000. Chapter 9, Hiya Hiya. We're getting it done, we're getting it done. Equal Credit Opportunity Act. Federal Fair Housing Laws. Andres, did you translate Hiya Hiya? Give everyone a Hiya Hiya. Okay, we're moving on. The Federal Equal Credit Opportunity Act prohibits discrimination in lending based on race, color, religion, national origin, sex, marital status, or age, provided on individual is of legal age. The anti-discrimination rules apply to institutional lenders, mortgage brokers, and others who make or arrange mortgages. Discriminatory practices take many forms, including treating minority mortgage applicants less favorably than non-minority applicants, placing additional burdens on minority applicants. I'm going to spit all these marbles out really quick. All right, here we go. We're back. That was weird that I had all those marbles in my mouth. Thank you for translating, Andres. I see you doing that over there. Placing additional burdens on minority applicants, requiring a spouse's signature on a mortgage application when an applicant qualifies for a mortgage individually, discouraging mortgage applicants based on their race, color, sex, etc., and making inquiries into the marital status of mortgage applicants. The lender may not make any inquiries into whether an applicant's income is derived from alimony or child support. The lender may not inquire whether the applicant intends to bear children. Further, to deny, that's a weird question, further to deny a mortgage based on an applicant's receipt of income from a public assistance program such as welfare or Social Security is unlawful discrimination. However, discrimination is rarely practiced overtly. Most lenders are not transparent enough for the consumer to see the discrimination. Most often, discrimination takes the form of a lender denying a mortgage to a minority borrower without a valid reason, or applying different standards to minority and non-minority borrowers. Different treatment is discrimination. Lenders need to be careful not to provide more assistance to non-minority borrowers than to minority borrowers when preparing applications and working out problems which arise. The different treatment of minority and non-minority applicants is another form of unlawful discrimination. For example, an African American couple applies for a mortgage to be insured by the Federal Housing Administration, the FHA, which will fund the purchase of a residence. The home of the couple seeks to purchase is 75 miles from their place of work. The couple intends to occupy the home as their principal residence and commute to work. The lender suspects the couple wants to purchase their home as an investment and not to occupy it themselves. Since the type of FHA insurance sought may only be used to purchase homes which the buyer will comply, the lender denies the mortgage application. The lender does not discuss the couple whether they intend to occupy the home. Also, the lender never suggests the couple can apply for a non-FHA mortgage. Due to a mortgage contingency, the couple loses their right to buy the home and incurs expenses in the process. The couple seeks to recover their money losses from the lender under the Equal Credit Opportunity Act, claiming the lender's denial of their mortgage application was due to unlawful discrimination. The lender claims the denial of the mortgage application was proper since it believed the couple did not intend to occupy the home and thus did not qualify for an FHA-issued mortgage. Lenders are to provide the same level of assistance to non-minority borrowers. I don't know what that noise was. Oh my gosh. I'm really sorry, guys. My face just doesn't want to do this anymore. Lenders are to provide the same level of assistance to non-minority borrowers as minority borrowers. Thus, the lender may not unilaterally decide the couple may not intend to occupy the home without first discussing the couple's intentions with them. Also, even if the couple did not qualify for an FHA-insured mortgage, as a matter of professional practice, the lender needs to refer them to other forms of financing. Thus, the lenders discriminated against the African American couple by denying their mortgage application without a valid reason. Further, there was a failure to use diligence in assisting the couple to obtain financing. Differing levels of financing. Differing levels of assistance. Consider a California regulated institutional lender who regularly arranges alternative forms of financing. The lender consistently informs non-minority applicants of their financing options when they deny a mortgage application. The lender's failure to diligently provide the same assistance for minority applicants subject to the lenders to liability for the minority applicants' money losses caused by the discrimination. Here, the unlawful discrimination is based on the lender's selective release of information based on status. Discrimination by age and public assistance. Some exceptions to the anti-discrimination rules exist. For example, a lender may lawfully consider a mortgage applicant's age when that is the alarm, but we have 7 more minutes left in class. I would like to continue to pound these out here for you guys so that you guys have less reading. We're on page 75. We have, what did we say? We said we're going to 81 today? 85. We've got 10 more pages. Let's see what we could do here really quick to make sure that you guys don't have any homework. Okay. Some exceptions, like we said. For example, a lender may lawfully consider a mortgage applicant's age when determining the applicant's creditworthiness. A lender may also consider whether the applicant receives income from public assistance programs, if such an inquiry for the purposes of determining the amount and likely continuance of income levels for public assistance. Editor's note: allowing lenders to consider an applicant's age or receipt of income from public assistance programs as an exception in determining the applicant's creditworthiness effectively removes these two factors from the anti-discrimination protection previously discussed. While a lender may not refuse to accept applications or impose different mortgage terms based on applicant's age or receipt of public assistance income, the lender can lawfully deny a mortgage based on these factors simply by stating the applicant is not creditworthy. Further, the lenders may consider an applicant's immigration status when considering a mortgage application. Immigration status is used by the lender to determine whether the applicant is a permanent resident of the United States. Denial of credit and notification. After the lender's receipt of mortgage application, the lender has 30 days to notify the applicant as to whether the mortgage is approved or denied. If the lender denies the mortgage, the lender is to deliver a statement to the applicant listing the specific reasons for the denial. Alternatively, if the lender does not give the applicant a statement of the specific reasons for the denial, the lender is required to deliver a notice to the applicant stating the applicant has a right, upon request, to obtain a statement listing the reasons for the denial. In addition to the Equal Credit Opportunity Act, California law controls credit reporting agency. Consumers may request a free copy of their credit report once every year to review it for errors. Penalties for discrimination in lending include actual money losses sustained by a person who has been discriminated against and punitive money awards up to $10,000 plus attorney fees. Chapter 10 summary, blah, 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 blah. Home Mortgage Disclosure Act. Here we go. Lenders release home mortgage disclosure data. The Federal Home Mortgage Disclosure Act, HUMDA, seeks to prevent lending discrimination and unlawful redlining practices. The HUMDA requires lenders to disclose home mortgage origination information to the public when the borrower is seeking a residential or home improvement mortgage. State and federally regulated banks and mortgage brokers are required by the HUMDA to compile home mortgage origination data. This data is submitted to their respective supervisory agencies. Home mortgage originations include purchase assist financing, construction for a new home, improvement of the borrower's home, or the refinance of an existing home mortgage. Federal disclosure requirements. Lenders with total assets of more than $28 million and for-profit mortgage brokers with total assets of more than $10 million need to compile origination data and make it available to the public. The data includes the type and purpose of the mortgage, the owner and occupancy status of the real estate securing the mortgage, the amount of the mortgage, the action taken by the lender of the application, the sex, race, and national origin of the mortgage applicant, and the income of the mortgage applicant. The data is grouped according to the census tracts to determine the lender's activity within the tract. Lender exemptions. Lenders are exempt from HUMDA disclosures requirements if the lender does not have a branch office in the Metropolitan Statistical Area, MSA. The lender's assets of the preceding December 31st totaled less than $28 million. For-profit mortgage brokers are exempt from HUMDA disclosures requirements if on the preceding December 31st, the mortgage broker did not have the branch office in the MSA, or the mortgage broker assets totaled less than $10 million and they originated less than 100 home purchase mortgages in the preceding year. Regardless of exemptions, all lenders by the Department of Housing and Urban Development are to report to HUD and disclose the census tract information on all Federal Housing Administration mortgages they originate. The data is compiled by the Federal Financial Institutions Council into a disclosure statement sent to the lender. The disclosure statement is required to be posted in the conspicuous location in the lender's office where it is readily accessible to the public. The disclosure is posted for a minimum of 5 years. On request from any member of the public, the lender is to make available a copy of the disclosure statement data. California's state-regulated lenders. Lenders who regularly originate residential mortgages who do not report a federal or state regulatory agency are to compile data on the number or the dollar amount of mortgage originations for the fiscal year. This includes both actual originations and completed mortgage applications. State-regulated lenders who fall into the category include insurers, mortgage bankers, investment bankers, and credit unions that do not make federally related mortgages. At this point, we've got 1 minute left in class, and we still have this last chapter, which we're not going to get to. So you guys will have chapter 12, which is 4 pages for homework. Again, like we said, you guys can get the books on CalPACES. All of these books, all of the tests are going to be open book. So you can actually, when it comes time to take this first test, which we will do here in 4 weeks, you're going to be in a situation where you're taking it open book. So you're going to have a PDF version, and so imagine how hard that would be to fail. So I suggest getting that when the time comes. And of course, we're going to give you plenty of time, which is why we wait for the scholarship round. We wait the 3 weeks. We allow you to participate in the program, and then we set you up with that scholarship so that your 18 days can start ticking before you actually have to take that test. Okay, at this point, I'm going to check to see if there's any more questions in the Zoom, which there are not. I'm going to give a moment for any questions to come in here, and then we're going to wrap it. I'm going to check to see if there are any questions on Facebook, which there are not. Okay, so tomorrow is day 4 of the program. Day 5 will be a little bit more fun. We'll engage in a Socratic discussion. You'll get a chance to tell me why you got into real estate. So I would strongly encourage you guys to participate in that live conversation. I appreciate everybody tuning in. We'll give it, oh, no more questions. Everybody have a great day. I will see you tomorrow morning at 9 o'clock for day 4 of our real estate school. Have a good day, everybody. And any questions here in Zoom? Nope. Everybody have a great day.